Welcome back to the channel and thank you for watching. I'm a barrister of England and Wales who helps you understand law. Sky News reports that Johnny Depp has settled the case with Greg Brooks out of allegations he made from 2018. Now, many people will conclude or assume or infer that a settlement of a claim means that the claim was well-founded. So, spoiler alert, that's not exactly true. Many cases are settled without any admission of liability, and that is what I'm going into detail about in this video. But firstly, a brief overview about what this claim was about. Greg Brooks, who's aged 59, made allegations against Depp that during the filming of the movie City of Lies, allegedly Johnny Depp had screamed obscenities at him, hit him twice in the ribs, and then offered him money to punch him back. Now, many of you might remember from my previous video that this was due to go to trial and Camille Vasquez was due to represent Johnny Depp. But however, it now appears that there's a settlement which apparently reads, the settlement agreement conditions dismissal of this matter on the satisfactory completion of specified terms that are not to be performed within 45 days of the date of the settlement. And a request for dismissal will be filed no later than the 1st of May 2023. Now that's about all that this settlement appears to say at this time, because typically settlements like this are confidential. But allow me to explain why this does not automatically mean that Johnny Depp did those things that he's accused of, which I'm sure many people on social media are going to jump to the conclusion that he did, particularly if they are not supportive of Johnny Depp and supportive of others. In fact, I've already seen tweets about this many weeks ago, essentially saying that the filing of this lawsuit confirms all the allegations against Johnny Depp in the Amber Heard trial. Now, not only are they separate trials and you cannot just link the two together like that, let's not forget that the jury did come back with a unanimous verdict to say that they did not believe any of these allegations against Johnny Depp and that the article by Amber Heard was defamatory. Remembering, of course, that if just one of those incidents alleged for him to have committed were true or believed by the jury, they would not have found in Depp's favour because ultimately then the article would not have been defamatory. So just as that side note, drawing the parallels between those two cases is a little bit far-fetched. However, back to this case and this settlement, as I said, the settlement of a case does not conclude and does not mean that someone is guilty and liable of these offences. It simply means that they want to get rid of the lawsuit. Now, let me give you an example. Sometimes in England and Wales at least, and it's sometimes referred to like this internationally, we have what we call a Calderbank offer. That essentially means an offer to go away. It means we don't accept any of the allegations against us. We don't agree with anything that you've said. However, instead of going through a long protracted trial, instead of the costs incurred of going through a trial, which I'm going to come back to in a moment because it's significant, the Calderbank offer essentially suggests, look, we don't believe you, we think this is nonsense, but it's a waste of our time. Here is something, whatever that something might be, to go away. That something might be an apology, whether well-founded or not. It might be money, it might be an agreement to do certain things, it essentially could be anything. Because an agreement which is sealed and confidential like this and agreed between the parties could essentially be anything that they wish. In other words, the court can only really order sums of money, or it can order injunctions, which is you must do this, you must not do that, and so on. The court can also order transfer of property and things like that, but I digress. Essentially, a court cannot order an apology or creative solutions, which often find their way into confidential settlement agreements. Now, as I say, we don't know what is in this settlement agreement as yet, but there could be a great number of things within it, and one thing that it does not mean, because we don't know what it says, it does not mean that he has admitted these allegations, and I would expect not, because after all, the case was due to go to trial and he may have just proceeded to defend the claim. Now, it's not exactly unusual, in fact, it's quite common in the aftermath of a big trial, particularly if it is well publicised, for people to come forward to make allegations, usually of a historic nature from several years prior, because they know that it is likely that the person who is in the media for the main trial is likely to want to try to settle this to go away. There are many previous such cases where there's been a large publicised trial and then in the aftermath of that, or even when the person dies, lots of other people come forward to make allegations against the estate because they believe that the estate is going to settle those claims and make them go away. This is not exactly a new phenomenon. Some people refer to that as a shakedown. But as I said, coming back to this Johnny Depp settlement of this lawsuit, we don't know what the settlement says. So if you see any of these posts on social media saying that because he has settled this case, it means that he has accepted liability and these allegations are true, please remember the contents of this video, because that is not what it means. The settlement will be confidential. Nobody will know what the terms of that are. But I do know there will be some accounts on social media jumping on this to say that this is proof that he is liable, that he is guilty, and so on. But take it from me, a practicing lawyer and a mediator in England and Wales. And as a mediator, I have mediated disputes where there's been an agreement between the parties without any admission of liability, just because it is cheaper, it is quicker, and it is under more control to come to an agreement between you than it is to go to court. Now, I did say I would come back to costs, which is often one of the factors that drives these settlements, with or without admission of liability. And even in England and Wales, where the loser generally pays the costs, at least where the costs are incurred and payable. And I say that because we have special rules for small claims. So personal injury claims are not more than £1,000 and monetary claims not more than £10,000. The costs are limited for those small claims. However, in the United States, of course, you have the American rule, as it's referred to, with regards to their costs. The parties pay their own costs. Now, for those of you that are not familiar with legal costs at all, or to a great extent, the largest costs incurred typically will be the trial. So there may be a cost number associated to that trial. So essentially the person being sued will have to weigh up, what is this trial going to cost me, and what might this person take to go away and not have the trial. And very often, if that number is less than the trial number, they make a settlement to go away. Now that might seem incredibly unfair to you, but those are the systems that we have. Even in England and Wales, the costs implication, what we call the litigation risk or the litigation costs risk of going to trial, can be significant. Parties can be arguing over something which ultimately will cost each party £100,000 when they go to trial, and if they lose, they've got the risk in England and Wales of paying the costs of the other side. So if both parties have incurred £100,000 of costs each and one of them loses, it's not just their own costs that they lose, but they will be paying the other party's costs as well. So this would be a £200,000 cost risk of going to trial. And we have all sorts of things such as filing cost budgets, which is essentially telling the court this is how much we expect it to cost. And then, of course, that document is used later on to restrict how much costs you can achieve against your opponent if you win. If you only say it's going to cost you £10,000 to defend the claim or whichever, whereas it costs you £100,000, the court is then going to say, well, we're going to limit your costs because you initially budgeted £10,000. But ultimately, these costs are one of the driving reasons that parties come to an agreement. So very quickly, with this simple analysis, you can see why parties might settle this dispute instead of going to trial, even when they are not admitting liability. In fact, very often they are not admitting liability. I've been in mediations where I'm the mediator, and I've been in mediations where I'm the lawyer, so I've seen it from different perspectives. I've also done in my training observations where I go with the mediator and I see the mediation with both parties, and I see the discussions of each lawyer and their respective client. Now, trust me, this is an interesting process because very typically each side are talking about what it would cost to come to something that each of them can be equally unhappy with. Now, that might sound very strange. You might think that someone will think that they need to win the case to go away happy, or win the mediation in a roundabout way. They don't win a mediation, they agree a settlement if the mediation is successful. But many people will think that to go away from a successful mediation, they have to walk away happy. That's usually not the case. It's usually quite the reverse. A successful mediation will very typically have each party walking away slightly disgruntled with what's happened, and that one party has had to pay money when they feel they were not liable. The other party receives some money, but not what they feel they deserve. Or they might want an apology, but they don't get an apology. They might want a public apology, and they don't get a public apology. They might get, in the mediation, they might get something along the lines of, here's our Calder Bank offer. We don't believe you. Here's £1,000 or $1,000 or whatever the case might be to go away, because otherwise we're going to trial and you will have to pay all of your trial costs. And in England and Wales, if you're unsuccessful, you will have to pay our costs of defending the claim. Case in point, one of the cases that I've worked on is one of the world's largest designer fashion brands. They spent almost £10,000 defending a claim for something that was worth a little over £2,000, even though, because of the size of the claim, they would never have been able to recover those costs unless one party had been particularly badly behaved during the litigation. So having spent so much defending the claim, essentially out of principle, they simply did not want to admit that they were wrong. However, most people are not in that fortunate position of having those deep pockets to pay for these trials. So ultimately, a lot of people will just take a sum of money instead of an apology if that's what they really wanted, instead of an admission if that's what they really wanted, and against the risk of going to trial. So as I said, remember, none of this means that in this settlement, none of it means that there's an admission of liability. In fact, that's pretty rare. An admission of liability is quite rare. Most individuals and most companies will simply defend a claim as against admitting liability. They may on some occasions admit liability in private in a mediation, but that's typically not public. And as I said, we do not know the details of this settlement. So I hope that's been enlightening. I hope that has helped you to understand how settlements work, how you cannot and must not simply draw an immediate inference and assumption, as many people will on social media. So look out for those comments, because they will be coming thick and fast, making these assumptions and making these declarations that this must mean X, Y, Z. So I hope that's been helpful. And in the meantime, please remember to like and subscribe. And of course, thank you for watching.